Vanakkam friends, let us take 10 more questions in this video and learn. As always, keep your copy of the Constitution of India handy or the app on your mobile phone. Pause the video after every question, mark your answer and only then proceed to listen further. If you wish to check the channel out for all these questions in one place and a PDF as well that you can download, please see the link in the description of this video. So let's get ready for 10 questions in this video. And the first one is, which of the following statements is or are correct regarding the chairperson of Rajya Sabha? Now, in this regard, I will direct you to Article 92 of the Constitution. It's just a few lines there. You can quickly read that. The first statement says the chairperson cannot preside over a sitting of the House where a resolution for his or her removal is under consideration. This is absolutely correct. I'm sure you knew that. That the chairperson, whether it is Lok Sabha or Rajya Sabha, both houses, when the proposal is being discussed for their own removal, then they cannot be presiding over the session. So they have to sit in the House. Just like other members. Then it says the chairperson has the right to speak and the right to vote in the first instance while a resolution for his or her removal is under consideration. Now see, understand this slight point here. In a Lok Sabha, because the speaker is a member of the House, when the speaker is sitting in the audience, in the House, not in the chair of speaker, then the speaker has the right to vote as a member of the House in the very first instance itself. When the speaker is in the chair, then the right to vote is not there in the first instance. The right to vote is there in the case of a tie, right? The casting vote. Now, if you see that in Rajya Sabha, the question here, the chairperson not being the member of the House, right? So, when they are not on the chair and they are in the House, then they have no right to vote because they don't have the membership of the House and only a member can vote. Right? When the chairperson is in the chair, at that time they can vote in the case of a tie, right? Because that is the power of the chair. But when the chairperson is not in the chair, then they don't have any power specifically given to them. So in that case, they are not a member and hence the right to vote is not there even in the first instance. It's very logical and also provided in Article 92. So the second statement is actually incorrect. So it will be good if you can go through the article actually once. In Lok Sabha and Rajya Sabha, there is slight difference there. So I hope you got the point. Moving on, which of the following persons are eligible for appointment as a judge of a high court in India? I have already told you that you should have read the provisions of Article 124, which is there for the Supreme Court, and Article 227, which is there for the High Courts. The first provision says a citizen of India who has for at least 10 years held a judicial office in India. This is correct. This is a provision in the Constitution. Similarly, second is also there, a citizen of India who has for at least 10 years been an advocate of a High Court. However, the third point, that a citizen of India who is a distinguished jurist. Now that is actually not a provision for high courts. That is a provision actually for the Supreme Court judges, though it was added, but then it was removed again later. Distinguished jurist is not eligible criteria for the judges of high court. It is there only for the Supreme Court judges. Right? Now, what is or who is a jurist really? That is something I would ask you to Google and try and understand. I did leave you with one of the relevant words in the previous videos. So please make sure you also understand what is or who is a jurist. So in this case, only the two statements are correct. So the next question we have is, which of the following statements is or are correct regarding the governor of a state in India? A governor of a state in India. Governor shall be eligible to be elected as a member of the state legislature. Now there is no such requirement like that. In fact, the qualifications of the governor, they are mentioned in Article 157, and all it says is that the person should be a citizen and the minimum age of 35 years. That's all. There is no other qualification as such. And even in the conditions of the service, there is no such provision that you should be eligible to be elected as a member of state legislature. However, if you compare this with the President of India, there is a provision that the President of India should be eligible to be a member of the House of People, the Lok Sabha. But for Governor, there is nothing like that. So this is actually wrong. Then it says Governor is not eligible to hold any office of profit after retirement or demitting office. There is no such condition in the Constitution. So this is also actually wrong. And if you apply a little logic, there is no real necessity to make a provision like this, that they shall not hold any office of profit post-retirement. Governor is not an entity independent of the government, or even one who is to impose some kind of a check and balance on the government. So this kind of provision is not required. I'm sure you know that many governors, they become governors again and they hold many other posts. Many of them become ministers in the union. So this is actually wrong, and hence none of these should be your correct answer here. So moving on to the next one. The subject of urban local government is managed by which of the following ministries of the Government of India? I don't think it should have been that difficult, but anyway. So Ministry of Defence, I'm sure you know, we have cantonments, Cantonment Board, etc. Those come under the Ministry of Defence. They are one type of urban local bodies. Ministry of Home Affairs, you can easily understand all the union territories. They are under the Ministry of Home Affairs. So in the union territories, let's say Delhi or Puducherry or others, wherever urban local bodies are there, they are actually, the Ministry of Home Affairs has a role to play there. Ministry of Housing and Urban Affairs, the most obvious and commonsensical thing. Yes, absolutely. Most of the schemes of the Housing and Urban Affairs, they are managed through the urban local governments of India. For example, let us say the Swachh Bharat Mission Urban, or your Smart City Mission, or things like that. Ministry of Panchayati Raj, common sense says they will have no role to play in urban local government. They have a role to play in the rural local governments. So basically the first three are your correct answers. And you should also know that there are roughly little more than 4,500 urban local bodies in India. While the rural local government bodies, the panchayats at all three levels, they are little more than 250,000. So that's a huge setup in itself in our country. Anyway, moving on to the next question. Which of the following statements is or are correct regarding disqualification of members of legislature under Anti Defection Law? Anti Defection Law is a very, very important topic. Let's take this question. Let's see one by one. It is applicable only to the members belonging to the recognized political parties and nominated and independent members. No, it is applicable to all the political parties, right? It applies to all the members. Essentially, you should just understand it applies to all members of the House. Anybody who is a member is under Anti-Defection Law. Yes, some specific exemption may have been given. But that's a different thing, but everybody is covered, and hence you should be able to answer the third point also. It does not apply to the Speaker of Lok Sabha. Absolutely wrong. It does apply. Yes, certain actions of the Speaker are exempted. For example, if the Speaker resigns from their party when they are elected as a Speaker and they don't join any other party and then come back to the same party after completion of term, then they will not be disqualified. But it does not mean Anti-Defection Law does not apply to them. So if they do anything else, for example, if the person who is elected as a speaker, they resign from the party and they join another party, then they will also be disqualified. In fact, if you see Anti-Defection Law, there is a very clear provision that while the decision is taken, by the speaker for the members, but when the question is of the speaker itself, then the deputy speaker will take that decision. So it is very clear that speaker is essentially the principle is all members, okay, any type of members. Then second statement says it does not apply to mergers, but it applies to the splits of legislative parties. I'm sure you know that yes, mergers, and the merger is defined where not less than 2/3 of the party members, they break and merge with another party, right? They have to merge also. Earlier splits were also protected. But now the split is not protected. Now what is a split? Split was defined as minimum 1/3 of the members splitting and forming a new party, right? Please ensure you understand the difference between merger and splits. So yes, the second statement is correct, but the first and the third, they are wrong here. So please ensure anti-defection law you understand very in detail. Just go through the provisions once, it will all be simple enough, and through the questions that we will have in this series, more finer nuances will be completed. So we go to the next question: which of the following statements is or are correct? So if you see here, when the office of the speaker and the deputy speaker is vacant, see, it's vacant, a member from the panel of chairpersons presides over the session. No, panel of chairperson presides when the speaker or the deputy speaker, they are absent, right? They are on holiday, they are on leave, they are not in the house for some reason. But when the seat is vacant, that means there is nobody who's a speaker and there is nobody who's a deputy speaker. Then in that case, it is the president who will appoint, right? The president will appoint somebody temporarily, and that's why they are called pro tem. This is another thing which people get confused, that pro tem is not just the one who's appointed after the election only. Pro tem is a temporary speaker appointed by the president. Anyway, this will come in another question where we'll go in more detail. So it is the president, so first is wrong. Then secondly, the oath of the office of the speaker is administered by the president. First thing, there is no oath of office of the speaker, right? There is no oath of office of the speaker. Yes, the speaker is a member, so their oath will be there only as a member of the house. And that oath is administered, like all the other members, by the speaker pro tem. By the speaker pro tem, right? But that is not the oath of office of the speaker. Please understand, who is taking the oath? It is not the speaker taking the oath, it is the member of the house taking the oath who later will become the speaker, right? So there is no separate oath anyway. So this is wrong as well. So both of the statements are wrong for you. So the performance has actually not been very impressive, even though these are very basic understanding questions for us. So next question: which of the following statements is or are correct? Nominated members of parliament cannot vote in the election of the President of India. I'm sure you know that this is correct, because election of the President is actually a method of indirect election is used, where ultimately it is the people of the country who are voting indirectly, and hence only the representatives of the people will vote, and thus the nominated members, they don't have any vote to cast there. Okay. Second statement says the nominated members cannot vote in the impeachment process of the President of India. Now see, understand this. The impeachment process of the President of India, this is done by the Parliament of India. Election is by the people of India, impeachment is by the Parliament of India, right? So when we say Parliament, elected member, nominated member, doesn't matter. Parliament consists of all types of members. So this is a wrong statement. They can definitely vote. Then third, nominated members of parliament cannot vote in the election of Vice President of India. See, election of Vice President of India, it is again done by the Parliament of India. So parliament means entire parliament. So this is also wrong statement. Then nominated members of parliament cannot vote in the removal process of the Vice President. Again, the removal of the Vice President is done by the Parliament of India. Okay, so understand this. Many people a lot of time ask this question: sir, why nominated members, they are not allowed to vote for president, but they can impeach, they can participate in the impeachment? See, these are two different processes, and the concept behind them is different, right? So this is also done, Vice President's removal is also done by the Parliament of India, hence all members vote. So this is also wrong. Only one of the statements is correct. I'm very happy to see that good number of you could answer this question. So the next one we have, the term Amicus Curiae is often in the news related to cases in the courts of law. What do you understand by this term Amicus Curiae? See, in some way, all these will have some kind of a relation with Amicus Curiae. Okay, so if you ask which of them is the best definition of Amicus Curiae, that is what we need to understand here. See, Amicus Curiae is a Latin phrase which simply means a friend of the court. Okay, a friend of the court. So a person who is not a party to the case, okay, but volunteers to offer information on a point of law or some other aspect of the case to assist the court, okay, to assist the court, in the matter that is to be decided. And the information may be a legal opinion in the form of a brief, testimony that has not been solicited by any of the parties to the case as such. And the decision whether to admit this information lies with the discretion of the court. So the court will decide, okay. And in India, you will see that if a petition is received from the jail, okay, or in any other criminal matter, if the accused is unrepresented, then an advocate is appointed as amicus curiae, right? So there is an advocate sometimes appointed to defend, right? To defend the case, to help the person who is unrepresented, not really to prosecute. Also in civil matters, the court can appoint an advocate as amicus curiae if it thinks that it is necessary in case of an unrepresented party. Okay. The court can also appoint amicus curiae in any matter of general public importance or in which the interest of the public at large is involved. So the court is the one who will take all these calls. So if you understand the basic concept, you'll see that the best answer for us, which truly defines the meaning of amicus curiae, is an impartial advisor to the court in a case. Okay. So while they could be experts in the field as well, they could be, defending a lawyer appointed by the court, or they could be, as such, helping the court in understanding and explaining the case. Maybe the theoretical aspect of the law they elaborate. So the correct answer here, the most appropriate answer should be C. So we move on to the next question, and that is, in the areas covered under the Panchayat extension to scheduled areas, that is your PESA, what is the role of Gram Sabha? Gram Sabha has the power to prevent alienation of land in the scheduled areas. I'm sure we know they do that. Gram Sabha also has the ownership of minor forest produce. See, I'll tell you one thing. Most people have never read PESA. Actually, they just read provisions here and there. I will sincerely recommend that you please go through the provisions of PESA. They are not too many. The entire PESA document is hardly 4 pages, right? So you can just Google PESA, go to the website of the Ministry of Tribal Affairs, or even the Panchayati Raj, MOPR, and you'll be able to just download it and just go through it once and maybe once more before the exam. I have seen UPSC tends to love to talk about PESA more than Panchayati Raj. They love the Panchayat extension provisions. So please read that. Now, recommendation of Gram Sabha is required for granting prospecting license or mining license of any mineral in the scheduled areas. Now, this is actually a statement which came earlier also in the exam. See, there's a lot of confusion here I see also because of the Vedanta judgment in 2013. If you see PESA, the provision very clearly says that it is the recommendation of Gram Sabha is required only when the lease is for the minor minerals. Okay, for minor minerals. See, we define minerals into minor and major. From your geography understanding, you should be very clear. If you are not, please go and revise that. This is a point of learning for you. So only for the minor minerals it is there, not for any mineral. Some confusion does happen at times. I have seen in discussions that in the Forest Rights Act, which was something which came up in the Vedanta case, the mining in the Odisha, bauxite and things like that. So in that case, the Supreme Court interpreted the provisions of FRA in relation with the provisions of PESA also. They took help of PESA, but ultimately they interpreted Forest Rights Act, and they said that the Gram Sabha has the ultimate authority in deciding the individual rights or the community rights of the people with regards to the forests. Okay, and that should be actually considered as final. They did not say that can it be reviewed, can somebody change that, but in a way that is the message they have given there. But see, this question is specifically talking about PESA only. So through PESA, the Gram Sabha doesn't get any power beyond the minor minerals. So this actually, I would say, be considered as a wrong statement for this reason. So again, the performance, it's glaring. So we come to the last question of this video. Which of the following statements is or are correct regarding the Attorney General of India? The provisions of Attorney General, we have one article, Article 76. Please read that, and it should be, sufficient enough to give you a lot of guidance on the Attorney General's issue. AG can take part in the proceedings of Lok Sabha, absolutely correct. AG can be a member of committee of the Lok Sabha, this is also correct. AG can speak in the Lok Sabha, yes. They can, AG can be, a part of any of the houses as such in terms of the proceedings and the appointment to the committee. But of course, since the AG is not a member of the house, AG cannot vote. AG cannot vote in any of the houses. They can only participate, speak, contribute, give their ideas. So this fourth statement is actually a wrong statement. Okay. Please revise your provisions of Attorney General. In one of the previous questions also we did see some of the ideas regarding the Attorney General, the first law officer of the country, the term, the term of office, the appointment, the remuneration, etc. All those things. More issues will come up in further questions. So those were the 10 questions for today. And today I thought while you guys and girls read and watch a lot of videos in the TV and the web as well. So those of you who are kind of interested, I thought I'll recommend one from my side which will also help you in learning, and I think it's a very good series which came a few years ago on Rajya Sabha TV, Samvidhan. I'll put up the link in the description for this series, but anyway, you all are very good at using Google. So on YouTube, the entire series, 10 episodes are there, 1 hour each. I'm sure you'll learn a lot. They are great research pieces that have been there. You will see great actors, but more than that, what I think you should be able to take it out, that yes, we have many problems in our country. We are not the best country in the world. We have so many things which are wrong, but yet it is working, and it is working because of our constitution and because of the philosophies of the great people the constitution makers had while they were making them. So listen to them, and I think if all the citizens of this country, all the civil servants of this country especially, but every person, if they understand these philosophies, again, I am totally sure that we will become the great nation we want to be. So thank you very much. I'll see you in the next video with 10 more questions.